bundle, which includes the skeleton arguments and the judgment, a supplementary bundle, which includes the license and settlement agreement, and an authorities bundle in a single volume.
Yes, indeed. And we have obviously read the judgment and the skeletons.
I'm most grateful. Mr. Saunders raised with me before the hearing began the question of the confidential information to which the judge makes reference at paragraphs 11 to 12 of her judgment, specifically the financial information in the licence. And I'm not intending to take the court to it, but I obviously don't want by simply taking the court to the document to go behind the fact that the judge didn't include the details in the judgment. And so Mr. Saunders has suggested a pro tem 3122 order to deal with that.
Makes perfectly good sense. Yes, all right, we'll make that order.
I'm most grateful. I was going to structure my submissions under 4 headings. First of all, a brief introduction to the background facts against which the agreements were concluded. Secondly, the principles of contractual interpretation relevant to the resolution of the appeal. Thirdly, the provisions of the 2 agreements themselves, and particularly the key clause 10.1 of the licence. And fourthly, I was going to develop each of the 5 grounds of appeal in turn, explaining why we say the judge erred, and picking up and responding to the points made by BT in its skeleton as I go. So turning to the first of those 4 topics, the factual background to the agreements. There are a number of locations in the bundles where the court will find the background. Most importantly, of course, there's a judgment that the court has read at tab 10 of the core bundle. There was a statement of agreed facts in the High Court, which is at tab 15 of the supplementary bundle. And as I'll be showing the court in due course, at the start of the settlement agreement itself, which is in the supplementary bundle, there's a relatively detailed agreed history of the litigation between the parties which led to the agreements. As the court will have seen, this case is about digital subscriber line or DSL technology. DSL is, as the court knows, the technology which allows the existing copper telephone lines to be used as a means of delivering data at high speeds. Professor John Choffey, who's the founder of my client, ASSIA, played a significant part in the development of that technology from the late 1970s onwards. And of course, the need for DSL technology arises because historically the only telecommunications connection into premises in the UK and indeed elsewhere consisted of copper wires originally designed to carry voice calls. And DSL technology enables telecoms companies to use those wires to transmit data at high speeds. And DSL technology relates, as is explained in the judgment, to the part of the network between, on the one hand, the customer's home, and on the other hand, either the BT exchange, or else in the format that we're concerned with in this case, the BT street cabinet. Because the present case concerns fibre to the cabinet, where the only copper part of the connection is between the street cabinet and the customer's home or office. And the key feature of a DSL connection for present purposes is that it requires 2 modems at each end of the connection in order to operate. The modem in the street cabinet is known as the DSLAM, that's the Digital Subscriber Line Access Multiplexer. And the modem in the customer's home is either a separate standalone device in the so-called 2-box solution, or else is part of a single piece of customer premise equipment, CPE, and that's the so-called 1-box solution. And the essence of DSL is those 2 modems, one in the premises, the other in the exchange or the street cabinet, talking to each other to produce a service when they've established what's called showtime, and that's paragraph 18 of the judgment. Now, the modem in the customer's home, which forms part of the CPE in a 1-box configuration, is an essential part of a DSL system without which the system simply cannot function. And that's an agreed fact, statement of agreed facts, paragraph 12b. A further layer of complexity is that a DSL system will typically, in order to operate at higher speeds, use a form of what's called digital line management, or DLM technology. And as the judge explains at paragraphs 4 to 5 and 20 of her judgment, DLM is a system which monitors a DSL connection and reprofiles it from time to time to achieve the best performance. And at the time of the agreement, and indeed until May 2022, my client's primary business was in selling software to improve DSL performance, including its own DLM software known as DSL Expresse, and that's judgment paragraphs 2, 4, 24 and 30. BT's DLM system uses profiles generated by a device called the Rambo, the Rate Adaptive Monitoring Box, which directs the DSLAM to adopt a particular profile for best performance. That's judgment paragraphs 14 and 20. And it was that functionality for the NGA network, one of BT's 3 networks, that was found by the High Court and the Court of Appeal to infringe ASSIA's patents in 2013 and 2014, as we'll be coming to shortly. So the basic architecture of a DSL line is the 2 modems talking to each other using standardized DSL technology, but which is optimized by DLM. Now, to explain how the issue in the present case arises, one then needs to appreciate the overlay of regulatory obligations on BT, and that's addressed briefly in the Statement of Agreed Facts, which is in the supplementary bundle, tab 15, at page 239, please. And as the court will see at paragraph 4 on page 239 of the supplementary bundle, it's recited that BT owns and operates a significant proportion of the telephone wires and exchanges in the UK, and then there is a description of the various divisions relevant to the proceedings, including OpenReach. And we can see from the sub-paragraphs over the page that in the mid-2000s, as a result of the EU's CRF, the UK's Office of Communications undertook a regulatory drive to ensure that all communications providers had fair access to BT's networks. One benefit of this was that the retail market was made competitive, and then there's a description of how, to that end, OpenReach was created to make the network accessible to other CPs. And that was necessary, of course, because BT is the historical monopolist. It owns and operates most of the UK's telephone wires and exchanges, and critically, that includes the bit that's very difficult to replicate, namely the 100,000 street exchanges and all of the copper wires that go into customers' homes.
Sorry, you said street exchanges.
Sorry, my apologies. Street cabinets. There are 100,000 street cabinets and 1,000 exchanges.
So how far are most people from a cabinet?
I don't think we have any evidence on that. Certainly my own experience is not very far at all. But that's, I don't think there's any evidence in the bundles on that, my lord. Now, in terms of the stages in the introduction of competition at the retail level, the first type of unbundling was known as local loop unbundling. That's described by the judge in paragraph 21A of her judgment. And the relevant fact about LLU for present purposes, as you'll see from paragraph 21A, is that in LLU, the DSLAM, so that's the modem at the network end of the DSL connection, is located in the exchange, and it's therefore owned and operated by the CP itself. So that's Sky or TalkTalk or any of the other communications providers. From 2009, there was then a further variant to which the judge refers in the same subparagraph, known as sub-loop unbundling. And that was where communications providers installed their own DSLAMs, but this time not in the 1,000 exchanges, but rather in any one of the 100,000 street cabinets, so as to reduce the length of the copper wire by which the connection needed to function on. Now, as I mentioned earlier, at the same time as this unbundling process was going on, BT was also introducing what's called fibre to the cabinet technology. And that reduces the length of the copper wire by laying fibre all the way up to the street cabinet, so the only copper that you're using is that between the street cabinet and the home. And that gave rise to a new type of regulated access to BT's network known as VULA. And we can see the definition of that in paragraph 21b of the judgment. This is a form where BT provides a data connection rather than access to physical infrastructure, and does so all the way between the customer premises and a handover point in the network where the CP may connect their backhaul. And this involves using a BT DSLAM, either in the exchange or the street cabinet. This case concerns the NGA network where FTTC is in use, so the DSLAM will be in a street cabinet. But the handover point to the CP is in the exchange, so BT also provides a fibre connection between the street cabinet and the exchange. And as the judge records, there is also a data connection at the Ethernet layer, and she says this arrangement is sometimes referred to as virtual unbundled local access, or VULA. And as the judge explains there, although it's described as unbundled because of the broader regulatory background, all of which was about unbundling the local loop, in fact, as compared with LLU or SLU, VULA is actually a more bundled product because BT owns and operates the DSLAMs, and so there's no possibility for CPs like Sky or TalkTalk to use their own DSLAMs. So although it's virtual unbundled local access, it is also referred to by comparison with LLU as a bundled service. But in both SLU and VULA, the DSLAM is in the street cabinet. Now there's one last technical point which needs to be addressed, which is one box or wires only versus two box. That's in the judgment in various places, but at 15 to 16, 36 and 58. And the essence of this is that in each new generation of technology, the process has usually begun with BT itself providing a dedicated customer premises modem, which is separate from the router. That's known as a two-box solution. And as time has gone on, a one-box solution has then become available, whereby the modem and the router are integrated in a single piece of customer premises equipment. Again, perhaps confusingly, because under this option BT provides no boxes at all, it's also known as wires only. So one box and wires only are the same thing. And as the judge records at paragraph 16, one box is not only neater, but also facilitates the communications provider's brand recognition because it can design and apply its own branding to the single box which is in the customer's home. So there is a commercial attraction to the CPs having a one-box solution. Now, VULA is delivered by BT, as the judge records in paragraph 25 of her judgment, pursuant to a contract between BT and the communications providers called the GEA conditions, and we can find those in the supplementary bundle at tab 6.
Just before you go to the conditions.
Yes.
Just catching up. So in VULA, in a 2-box situation, the customer will have a box in their house that's marked BT.
Well, I don't think we have any evidence that it has BT written on it, but it will have been supplied by and is being effectively operated by BT, yes.
Whereas in a 1-box, the box will have been supplied by Sky.
Indeed. The GEA conditions are in the supplementary bundle at tab 6. And the relevant variant is called the GEA FTTC service. It's defined in Schedule 2 at page 159. That clause 2.1, we see the service uses a fibre to the cabinet network infrastructure architecture to provide connection between the communications provider's equipment installed in a BT exchange at the point of handover within the BT exchange and the backplate of the NTE, that's network termination equipment, located within the end customer premises and is served by products delivered by means of BT's copper access network. And I think I can then skip to the 4th line from the end of the clause. There is no handover to the communications provider at or within the PCP, PCP being the primary cross connection point, or any other intermediary point in the BT network between the BT exchange and the end customer premises. So there's no handover back to the CP or anything like that, and on the contrary, as the judge recorded at paragraph 77 of her judgment, BT has full control of the portion of the connection covered by VULA, there being no handover to the CP at any intermediate point. The final part to the background is then the patent litigation between the parties. There are some short summaries in the judgment and the statement of agreed facts, but the most detailed one is actually in the settlement agreement itself, which is in the supplementary bundle at tab 5, page 76. And as one can see from recital C onwards at page 76, we can see that in 2011, ASSIA issued a claim for patent infringement in respect of BT's DLM systems on all 3 networks. There was then a series of actions in the European Patent Office. In particular, as you'll see from D1 to 5, BT commenced opposition proceedings in respect of 5 different ASSIA European patents. And then at 6, you can see ASSIA commenced opposition proceedings against a BT European patent, which was revoked. As we can see from E, my Lord Justice Birss found that 790 was valid and infringed in 2013, and that 495 was valid but not infringed. The matter then went to the Court of Appeal, as we can see from F, which held that both of those patents were valid, and indeed that both were infringed. We then see that BT applied at G. We see that BT applied for a declaration of non-infringement as regards 790. There had been, BT considered that it had already worked around 495. That was unsuccessful, and it was ordered to pay £100,000 a week in lieu of an injunction. So BT was paying £100,000 a week in lieu. We see then BT initiated proceedings against ASSIA in Delaware, following which BT then issued another claim for a declaration of non-infringement as regards 790, and indeed applied for summary judgment in relation to that workaround. So by July 2015, when these agreements were concluded, the parties, I mean, this was essentially a classic situation of a multi-jurisdictional patent fight. The parties were litigating in the EPO, in Delaware, and in the UK. In the UK, BT's NGA network had been found to infringe 2 of ASSIA's patents. The first attempt of the workaround had failed. It had had another attempt. It was applying for summary judgment. BT was paying £100,000 a week, and the parties were about to commence on a damages inquiry. So this was a situation in which both parties would clearly and undoubtedly have wanted to settle if they could, but where the commercial incentives were necessarily divergent, in which each party would have wanted to give as little as possible to the other in order to settle. And it's against that background that the agreements were concluded. That's the first of my 4 topics. I turn now to the second, which is the principles of interpretation. We deal with the relevant principles of interpretation in our skeleton argument in the context of each of the first 4 grounds of appeal. There is, of course, as the court will be very well aware, a trilogy of Supreme Court cases which are referred to at paragraph 59 of the judgment and which will, as I say, be very familiar to the court. Rainy Sky and Kookmin, Arnold and Britton, and Wood and Capita. They're all in the bundle of authorities at tabs 7, 10 and 11. There have been various shorter summaries of the net effect of the trilogy, 2 of which the judge cites in her judgment at paragraphs 60 to 61, Minera, Las Bambas and ABC. And I'm not going to take time, given how familiar they are, going through all of the trilogy. Instead, I want to emphasise 5 points which we say are of particular relevance to the exercise of construction in this particular case, and give you the authority for those propositions. So the first is that the reasonable reader is equipped with all the knowledge and facts reasonably available to the parties in the situation in which they were at the time of the contract. There are many places one could go for that proposition, but I'll start with Investors' Compensation Scheme, tab 4 of the bundle of authorities. This is, of course, the extremely well-known dispute about the proper construction of an exception from the assignment of claims required in order for somebody to claim from the Investors' Compensation Scheme. Lord Hoffman's speech was agreed with by Lords Gough, Pope and Clyde. And at the bundle page 152, which is page 912 in the report, at H, the first principle, adumbrated by Lord Hoffman, is that interpretation is the ascertainment of the meaning which the document would convey to a reasonable person, having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. There's a further reference in Pink Floyd at tab 6. This was a contractual dispute between service companies owned by the band Pink Floyd and their record company EMI. And at page 172 of the bundle, paragraph 18, line 3, the Master of the Rolls, Lord Newburgh, as he then was, says, the words must be interpreted by reference to what a reasonable person who is informed with business common sense, the knowledge of the parties, including, of course, the other provisions of the contract, and the experience and expertise enjoyed by the parties at the time of the contract would have understood by the provision. And there are, as I say, further references one could give. Arnold and Britman, paragraph 21, and we've included a Lewison extract, but I don't think I need to take you through those as well. So it's the reasonable reader in the position of the parties, equipped with their experience and expertise and the knowledge reasonably available to them. So that's the first of the 5 points I wanted to emphasise. The second is that where the language is not ambiguous, the court must apply it. That's the Rainy Sky case, which is in tab 7 of the bundle of authorities. And if we go to page 193 of the bundle, page 2908 of the report, at the end of paragraph 21, the court will see that Lord Clark said if there are two possible constructions, the court is entitled to prefer the construction which is consistent with business common sense and reject the other. And then moving forward to paragraph 23, the proposition I rely on, where the parties have used unambiguous language, the court must apply it. And the task in the end is to work out what the parties, the language that the parties used means. And that's Schuler and Wickman. This is still under the same proposition. Tab 1, bundle page 29. The majority speeches in this case are those of all except Lord Wilberforce. Page 29 of the bundle, 263 of the report. Citing Norton on deeds, Lord Simon says there is, next to F, there is one general principle of law which is relevant to both questions. This has been frequently stated, but is most pungently expressed in Norton on deeds, though it applies to all written instruments. The question to be answered always is, what is the meaning of what the parties have said, not what did the parties mean to say? So that is the second point I wanted to emphasise. The third is that commercial purpose or business common sense can be invoked only where there are two possible constructions. I showed you that just now in Rainy Sky. The same point can be gleaned also from a case called BMA, which is in tab 8 of the bundle of authorities. This was a dispute between a commercial borrower and a lender about the interpretation of a loan facility agreement. And in the judgment of Lord Justice Akins at bundle page 208, line 5, Lord Justice Akins says, the court's job is to discern the intention of the parties, objectively speaking, from the words used in the commercial document in the relevant context and against the factual background in which the document was created. The starting point is the wording of the document itself and the principle that the commercial parties who agreed the wording intended the words used to mean what they say in setting out the parties' respective rights and obligations. If there are two possible constructions of a document, a court is entitled to prefer the construction which is more consistent with business common sense, if that can be ascertained. However, I would agree with the statements of Mr. Justice Briggs in Jackson and Deere, first, that commercial common sense is not to be elevated to an overriding criterion of construction, and secondly, that the parties should not be subjected to the individual's own judge's own notions of what might have been a sensible solution to the parties' conundrum. I would add, still less should the issue of construction be determined by what seems like commercial common sense from the point of view of one of the parties to the contract. There are further references I could give, including Cottonex, which is tab 9 at paragraph 55. Wood and Capita, tab 11, paragraph 11, and indeed Britvic, which I know my Lord Justice Nugee is very familiar with, which is in tab 14, and it's worth just taking you very quickly to that. Tab 14, page 308 of the bundle. This was a dispute about the proper construction of a clause in the defined benefit pension plan for employees and former employees of the soft drinks company Britvic. And the point I'm considering at the moment is picked up firstly by Lord Justice Coulson at page 323. Lord Justice Coulson was, as you can see, agreed with by the Master of the Rolls at paragraph 52, which is towards the top of that page. And one can see at paragraph 57, Lord Justice Coulson says, in the absence of ambiguity, it should be unnecessary to consider those arguments which are conventionally parasitic upon ambiguity, namely commercial common sense on the one hand, and excessive literalism or undue technicality on the other. As Lord Hodge explained in Arnold and Britain, those issues only arise for consideration if there's a basis in the words used and a factual matrix for identifying a rival meaning. If, as here, there's no such basis, those arguments do not arise. For the purposes of a point I'm going to come to later, but whilst we have the case open, I would also like to emphasise paragraph 59. And the reason for that is this, that as the court makes clear in paragraph 59, and it was also a point that my Lord Justice Nugee makes, as I'll show you in a moment, there is a difference between ordinary commercial common sense interpretation, where you have to have two possible constructions on the one hand, and corrective construction under the Chartbrook principle, where you don't have to have an ambiguity, but that is only where the court concludes that, as Lord Justice Coulson records, and using the language of Lord Hoffman from Chartbrook, something has gone wrong with the language. That's paragraph 59. And we can see from 61 that that is confined to cases where something has obviously gone wrong in a description, a date, a figure, a calculation, or whatever it may be. Turning then to the judgment of my Lord Justice Nugee, also agreed with by the Master of the Rolls at paragraph 52. The references I wanted to pick up are at paragraph 70 onwards at page 326. Having discussed the trilogy and also the Bernardo's case, which applied to pension deeds in particular, my Lord says, but those cases have also made entirely clear that one cannot jettison the language used by the parties. As both my Lords have referred to, the consistent teaching of the Supreme Court is that one does not get into the question of choosing which interpretation is more consistent with business common sense unless there are two rival interpretations available, and there is reference to Rainy Sky and to Arnold and Britain. And that is applied then in paragraph 71. The meaning of the rule in that case must therefore be approached by asking first if there are two possible rival interpretations. In the circumstances, this resolves itself into the question whether any other rate can reasonably be read or understood as meaning any higher rate. In common with my Lords, I do not think it can. And then moving over the reasons in that particular case, paragraph 72, I accept that language is a very flexible instrument. I also accept that language is never used acontextually and always has to be read in context. But there is, to my mind, a difference between, on the one hand, having regard to the context or factual matrix and to considerations of commercial common sense, with a view to resolving which of two rival interpretations is to be preferred, and on the other hand, having regard to such matters to create an ambiguity that's not there in the language. On the same point about Chartbrook, that's a point that my Lord also picks up on the facing page at page 328. At paragraph 75, my Lord says, in the second line, as well as choosing between rival interpretations, the court can correct mistakes as a matter of construction. It is clear from the Supreme Court authorities that this is a separate interpretative tool from those involved in choosing between rival interpretations. 76, these are cases where there's been a drafting mistake. And paragraph 77, this type of case is in principle quite different from the type where there are two rival interpretations. The reason I emphasise that is because at paragraph 66 of my learned friend's skeleton, BT skeleton, which is in the core bundle, tab 5 at page 71, my learned friend cites a passage derived from a case called McQuitty. So this is page 71 of the core bundle. And at paragraph 66, we'll see, having referred to Court of Appeal authorities applying the trilogy, my learned friend refers to, or friends refer to McQuitty, and then they say, in the latter case, the Court of Appeal recorded at 32 the observations of Mr. Justice Briggs. Now, those are from a case called Excalibur. And it says, commercial absurdity may require the court to depart even from the apparently unambiguous natural meaning of a provision in an instrument because the law does not require judges to attribute to the parties an intention that they plainly could not have had. Now, when one looks at McQuitty, it's clear from the citation from Excalibur that that is actually talking about the Chartbrook principle. So McQuitty is in the bundle of authorities at tab 13, page 302. In the judgment of Lord Justice Peter Jackson, first of all, it's recorded at paragraph 1 that the appeal raises no new point of law. And then at 302, paragraph 32, the learned judge says, I would also record the observations of Mr. Justice Briggs in Excalibur, and then there's the part that my learned friends include in their skeleton. Then 59, where something has gone wrong with the language, it is not, in my judgment, necessarily an objection to dealing with it in a way that avoids commercial absurdity, that provisions have apparently to be rewritten, blue-penciled or amplified so as to work rationally in particular circumstances. So what is being referred to here is the mistake principle, where you don't need an ambiguity. And indeed, that is clear. We don't have it in the bundle, unfortunately, but that's actually clear from paragraph 46 of the Excalibur case itself, which I have here, but perhaps my learned friend can consider the point, and if he pursues it, then I can hand it up. But as the Court of Appeal made very clear in the passages of Britvic that I've just referred to, there is a very clear distinction between commercial purpose in the ordinary sense, which requires two possible constructions, and Chartbrook corrective construction, on the other hand, which doesn't. Now, the fourth principle I wanted to emphasise is that even if there are two possible constructions, commercial common sense cannot be invoked retrospectively. It has to be assessed at the time of the contract. And in a sense, the classic case for illustrating that point is Arnold and Britain, which is at tab 10. This is one of the trilogy. Page 230. This was, as the court will, I'm sure, recall, a dispute about the proper construction of service charge clauses in leases for holiday chalets. And given their ordinary and natural meaning, the relevant clauses would have the effect that by the later years of the lease, the lessee would have to be paying more than £500,000 a year for service charges, as you can see from paragraph 30 of Lord Newberger's decision at page 242 of the bundle 1631 of the report, about 8 lines up from the bottom. If one assumes a lease granted in 1980, the service charge would be over £2,500 this year, 2015, and over £550,000 by 2072. And the lessees, perhaps not unnaturally, said this is a commercially improbable outcome for a service charge in respect of a holiday chalet, and it must be given some other meaning. And the Supreme Court rejected that proposition and gave the clauses their ordinary and natural meaning. And the point that I emphasise comes at paragraph 19 at page 239. Lord Newberger says, the third point I should mention is that commercial common sense is not to be invoked retrospectively. The mere fact that a contractual arrangement, if interpreted according to its natural language, has worked out badly or even disastrously for one of the parties is not a reason for departing from the natural language. Commercial common sense is only relevant to the extent of how matters would or could have been perceived by the parties or by reasonable people in the position of the parties as at the date the contract was made. That's the fourth point I wanted to emphasise. The fifth and final is that in order to be relevant, a commercial purpose must be a common or a shared purpose. Where there are divergent commercial interests, the words of the contract embody the compromise. I'll take that first of all from the Bank of Nova Scotia case, which is in tab 2 of the bundle of authorities, at bundle page 40. This was a claim by a bank against an insurer for breach of contract or negligence, consisting in the insurer's failure to inform the bank that the owners of a ship were using the ship in a prohibited zone, in which the ship was eventually sunk by Iraqi missiles. Lord Justice May gave the judgment of the court, which begins at page 853E of the report. The passage I rely on is at page 92 of the bundle, page 870 by letter G. There's a sentence beginning, "It is nonetheless important," in the 6th line. It is nonetheless important in attributing a purpose to a commercial transaction to be sure it's the purpose of both parties and not just one. If the purpose of the transaction is seen through the eyes of one party only, an unbalanced view of the transaction may result. Many contracts represent a compromise between what one party wishes to obtain and the other is willing to give. And naturally, as I submitted earlier, we say a settlement agreement is really a classic example of that sort of situation. There is then Melanesian Mission Trust, which is in the next tab.
See, before you go to Melanesia, you've been talking about commercial common sense and commercial purpose.
Yes.
It's probably utter a heresy now, but it's not obvious to me that they're necessarily the same thing.
My lord, I can see the point. They are, however, used pretty much interchangeably throughout the report. What we have done is put in an article in, let me see, which covers this point in tab 18.
Just before we go to the article, I mean, the passage you've just referred us to says, what seems to me to be conventional and unsurprising. It talks about construing a commercial contract to give full effect to the commercial purpose which the parties intend to achieve, so far as this can be inferred from the language they have used. Now, just pausing there for a second. That doesn't sound like that it's something that you would do only if there's an ambiguity. That's just what you do, you work out the purpose inferred from the language they've used. Are you saying that that only applies if there's ambiguity?
Well, the specific expression that's been used by the Supreme Court in the cases I showed you earlier is where there are two possible meanings. There is then there's a further debate actually in some of the authorities about whether that's the same thing as an ambiguity, and so I've deliberately used the expression two possible meanings rather than ambiguity, but it's two possible meanings is the expression that's used by the Supreme Court, and in the cases I showed you, it is said and held very clearly in my submission that it's only where there are two possible meanings that commercial common sense comes into play.
Well, I agree, but that's not what this is talking about. This isn't talking about commercial common sense. This is talking about the purpose of the contract as inferred from the words used. What I'm putting to you is that it's not, at least for the moment, it's not obvious to me that the task or the technique of applying considerations of commercial common sense in deciding between two rival instructions is the same task as the task of inferring the purpose of the document from the point of view of the language used. They're not necessarily the same thing, it seems to me.
My lord, I'll consider that, but I think it's fair to say that in the authorities they are treated pretty much interchangeably. One of the points that the article makes actually, it's page 353 of the bundle, tab 18. It does say there's more than one idea at play, and what it's done is listed out all the various expressions next to the first hole punch that have been used by the courts to embody the idea, and there are a whole series of different expressions which have been used.
Just, I mean, looking at, this is the second paragraph on that page.
Yes, indeed, yes.
Yes, I see.
Sorry, which page are you on?
Page 353 in tab 18 is an article about interpretation of contracts and commercial common sense, and a whole series of different expressions.
Yeah, none of them are commercial purpose. Unless I misread it.
For what it's worth, I share my lord's scepticism as to whether whoever the judge was it Lord Justice McGaw in the Bank of Nova Scotia, Lord Justice May in the Bank of Nova Scotia is talking about is the same as the commercial common sense line of authority. Commercial in Bank of Nova Scotia could be omitted without any difference to what he's saying, which is with every contract, one of the things that helps to inform what the parties meant to do is what was their purpose in entering into it. And that's a perfectly general point which has nothing to do, as my lord says, with resolving ambiguities or choosing between rival interpretations, or indeed to do with common sense, which is the thrust of the commercial common sense line. Again, you could omit the word commercial. We always try and give us a sensible meaning to contracts, because you start with a presumption that people don't intend to do things which aren't sensible. Sometimes people do things, as Arnold and Britain shows, which turn out not to be at all sensible. But on the whole, parties go into contracts intending to do something sensible. Now, as I say, that's a different proposition from on the whole. It helps to work out what the parties are trying to do in an overall sense by entering into the contract. So, for my part, I share my lord's scepticism as to whether the tag commercial means that these are dealing with two similar propositions. I think they're dealing with two different propositions.
My lord, taking that on board, even if one is restricting oneself, if one assumes that it is permissible to take into account business common sense only where there are two possible meanings, and yet always permissible to take into account commercial purpose, even if one is in the latter of those camps, the submission remains that it's permissible to do that only where you can identify a shared purpose.
I entirely agree. I
And-
don't have any difficulty with that at all, nor do I have any difficulty that when you're looking at what is sensible, because we call it commercial common sense or just sensible, as opposed to absurd or not sensible, it's not enough to say, well, this doesn't make sense for one party, if it makes perfectly good sense for the other party, and that very often the parties' intentions may be divergent, as you say. In the case of settlement is a classic case. So I don't have any difficulty with the proposition. But when assessing whether business common sense or commercial common sense helps to resolve genuinely alternative rival interpretations of a disputed provision, it has to be something which is sensible when looked at from the point of view of both parties. But I still think it's a different proposition.
Understood, my lord. I mean, it may not actually matter for the
probably
submission
doesn't
that I'm
matter for
advancing,
for
but I take on board the point that your lordships have made and obviously reflect on it. But the point about the words of the contract embodying the compromise comes up again in the Melanesian Mission Trust case, tab 3, page 130 of the bundle of authorities. Just to set this in context, this was a dispute between a lessor and a lessee about whether a clause in a lease requiring the lessee to pay a particular rent unless increased in a rent review prevented a reduction in the rent at a rent review. And we can see at page 130, Lord Hope, in the middle of the page, says, it is not necessary in this case to say much about the circumstances which provided the background to this contract or the commercial purpose of the transaction. And skipping the next sentence. On the one hand, there was the lessor MMT, whose primary interest in the transaction was to obtain a return on the money, etc. On the other, there was the lessee AMP, whose interest lay in securing terms for the letting of the property, which did not exceed those generally available in the market for similar premises. And essentially there's a further explanation of why the interests were divergent. And in the last 5 lines, Lord Hope says the balance which requires to be struck between these competing interests is a matter for negotiation in each case. The result of that negotiation is then set out in the formal contract, which supersedes the negotiations to which one must then turn in order to discover what was agreed. And adopting that invitation of Lord Hope, let me turn to the third of my topics, which is the wording of the agreements in this case. They appear in the supplementary bundle at tabs 4 and 5. The licence is at page 64. And on the point I mentioned earlier about confidentiality, although they are marked confidentiality, the net effect at trial, as the judge explained in paragraphs 11 to 12 of her judgment, that it was just the financial details that were confidential. So there's no sensitivity in relation to the reading of any part, actually, of the licence or the settlement agreement, save for the passage on financial terms, which I'll show you in a moment, so just so the court knows in terms of what one can say. The licence begins at page 65. ASSIA patents is defined, as you'll see next to the lower hole punch, as meaning all patents that ASSIA or its group own or control, and the claims contained, and then there's a whole series of specific ones, but it's all ASSIA patents. And that was, just so the court knows, there was actually an agreed announcement appended to the settlement agreement at page 90 of the bundle in the next tab that recorded that ASSIA had 250 granted patents and 250 applications. So it was a license of all of those patents. Returning to the license at page 65, ASSIA's field of use was defined as ASSIA's current and future products or services employing DSM technology that it licenses or sells directly to its end customers, including without limitation its DSL Expresse software. That's the software I mentioned earlier in the context of the background facts. BT patents are not defined so widely. On the contrary, they're defined as being limited to those which can be read onto, implemented or used in the field of DSM. And for these purposes, DSM can be taken to have the same meaning as DLM. I have no doubt that there are, if one were to burrow down into the detailed differences, but that's the relevant point for present purposes. BT's field of use is on the facing page. It means all of the current or future network or line management systems, products or processes, DLM or DSM management control systems, products, processes. One can go on, but one can see what it is directed to. It's the DLM, the software, the operation of the DSLAM to provide a DSL connection, all the things with which the case is concerned. We then have on page 67, the grant, it's worth just noting territory is worldwide on page 67. Then clause 3, or section 3, has clause 3.1. To last throughout the entire duration of this agreement, ASSIA hereby grants BT and its group a non-exclusive, perpetual and irrevocable, royalty-free and fully paid-up license to the ASSIA patents, etc. And the relevant limitation comes at the end with respect to the BT field of use in the territory. So it's a grant of a license with respect to the field of use as defined. And in 3.2, BT shall not be entitled to sub-license the license granted in clause 3.1 of this agreement other than to other BT group companies and related parties. There's no entitlement to sub-license. We then have the corresponding grant from BT to ASSIA at clause 4.1. To last throughout the entire duration of this agreement, BT hereby grants ASSIA and its group a non-exclusive, perpetual and irrevocable, royalty-free and fully paid-up license to the BT patents, etc. And again, one sees the limitation at the end of the clause with respect to the ASSIA field of use in the territory. ASSIA's entitlement in respect of sub-licensing is expressed differently from that in respect of BT. We see at clause 4.1, ASSIA shall not be entitled to sub-license the license granted in clause 4.1 of this agreement. However, the license granted in clause 4.1 above shall remain attached to all ASSIA products and services that fall within ASSIA's field of use, that are properly sold or licensed by ASSIA and properly used by its customers, all within the normal stream of commerce. And that's not language which appears in the equivalent clause 3.2 for BT. Moving forward through the license, we can see a description of the consideration in section 5, the duration in clause 6.1, which was the until the expiry of the last to expire of the patents. Clause 9 deals with acquisition or separation of group, and 9.2 about a spin out of OpenReach. 10.1 naturally I'll be coming back to because it's the critical provision, but let me just show the court the rest of the context before I come to it. We have in the clause 13.1, we can see that the parties were, as is unsurprising, being advised and represented by firms of lawyers respectively. I think we can then go to the settlement agreement, which is in the next tab. And I've already taken you through the recitals about the litigation. We have at 79, you can see in clause 2.1 that the agreement is conditioned upon the parties entering into the patent license in the form at confidential annex 8, so they are a package. And indeed 2.2, the settlement only comes into force once the license has been executed. There are then the provisions which I referred to in relation to the financial terms, which I won't read out, which are at section 3. Sections 4, 5 and 6 dealt with the dismissal of the different sets of proceedings. Section 7 was a release. Section 8.1 was a covenant not to sue. And there was then an entire agreement clause in clause 15.1, which referred again to the agreement together with the patent license. And they are both agreements governed by English law. My lords, I then need to come back to clause 10.1, which is the critical provision. That's at page 69 in tab 4. Headed clarification regarding patent laundering. The parties understand and acknowledge that the licenses and covenants not to sue granted hereunder are intended to cover only the products or services or networks of the two parties to the agreement and are not intended to cover manufacturing activities that either party may undertake on behalf of third parties, brackets, patent laundering activities. So the first sentence deals with manufacturing activities on behalf of a third party, and the expression patent laundering is used. The second sentence says, similarly.
I presume you accept that the first sentence is not relevant.
I'm not relying on the first sentence. I'm sure it's relevant in the sense that it's context for the exercise of construction.
To be sure, but it's not. You confirm you're not relying on it.
No, we don't say it comes in the first sentence. We say Vula comes within the second sentence, which says similarly. The licenses granted under this agreement are not intended to cover products and services provided by the parties to the extent that such products or services are provided on behalf of a third party, and then to the extent that such products or services are provided using materials provided by or on behalf of the third party. So that deals with products or services delivered on behalf of a third party. I'll come to the detailed points on construction in a moment, but just to complete the context, you then have the third sentence, which says, for the avoidance of doubt, this section does not apply to those products or services that fall within the ASSIA field of use or the BT field of use that are modified, supplemented or customised for customers in the normal course of business of ASSIA or BT or any of their group, and sold or distributed under a trademark or brand of ASSIA or BT or any of their group. So this sentence makes clear that the carve-outs in the previous two sentences don't apply to products within the fields of use if they are modified, supplemented or customised for customers and they're sold under the brand of BT. So the sentence makes clear that the parties expressly contemplated that the first two sentences of the clause could and would cover products and services which fell within each other's respective fields of use. And indeed, when one thinks about it, it could hardly do otherwise because this clause is a carve out from the licence grant. And the licence only grants rights to the parties within their respective fields of use, as per clauses 3.1 and 4.1. And in BT's case, that means the field of use as defined in the licence, which includes DLM, DSM, and DSLAMs, etc., as we've already seen. So, in order to have any function at all, clause 10.1 of the licence must function, as this third sentence acknowledges, as a carve-out from those other rights. And indeed, it's worth noting that one of BT's arguments below was that Vula fell within the third sentence. That argument was rejected at paragraph 92 of the judgment, subject to the judge's overriding point about end users, which I shall obviously come to, including on the basis that Vula is not modified for the benefit of any customer and is instead provided in the same form across the board. So the argument that the third sentence was satisfied was rejected. Now, returning to the second sentence, as the court will, I'm sure, appreciate having looked at the papers, our simple, straightforward contention is that BT's wires-only Vula service, if delivered using CPE provided by or on behalf of a third party, like Sky or TalkTalk, falls within each of the requirements of the second sentence. And just to set out our stall in relation to each of those three elements, first of all, Vula is indisputably a service provided by one of the parties, BT. And the judge found that Vula was indeed the relevant service at paragraph 66 of her judgment. Secondly, Vula in its wires-only form is provided using materials provided by or on behalf of Sky or TalkTalk, namely the customer premises equipment. And as I mentioned earlier, it's common ground that the CP is an essential component of the system which is used to deliver a DSL service, and without which the system couldn't operate. Indeed, BT delivers the service by a process under which the DSLAM is continuously communicating with the CPE. They're the two modems at either end of the connection. And as the judge recorded, in a one-box or wires-only arrangement, the CP is typically provided by the CP. That's judgment paragraphs 15 and 26. And again, the judge accepted that that was right, at least as a matter of literal interpretation of the words, at paragraph 81 of her judgment. She did then refer to passages later in the judgment, presumably those concerned with she says in the words in their contractual and wider context, which is a reference essentially to the later parts of the judgment which deal with issues like patent peace, business common sense, and I'll be dealing with all of those. But simply looking at the words, the judge accepted under paragraph 81 that that second requirement was satisfied. Thirdly, Vula is also, we say, provided by BT on behalf of the third party CP. And again, the judge held that if BT was indeed to be regarded as supplying a service to the end user, then again that requirement would have been satisfied. That's paragraph 80 of the judge's judgment. And that was because applying the authorities on the expression on behalf of BT's actions plainly engaged the responsibility of the CP. That's paragraph 80. And there's no respondent notice or suggestion that was wrong. So the critical reasoning is in the judgment is therefore paragraph 70 to 78, which I'll come to in the context of grounds 1 and 2. But we say just approaching the matter in an unvarnished, straightforward way and looking at the words, asking whether the requirements of the clause are satisfied. Clearly they are. Now at this point, whilst I'm on the words of the clause,
Well, just before you
indeed,
proceed,
my lord, yes.
can you help me as to the relevance or otherwise on your case of the subordinate clause at the end of it? And you've touched on this to some extent, but when it says, and then to the extent that such products or services are provided using materials provided by or on behalf of the third party, and I appreciate you say when you satisfy that because of the CPE. I've got that point. But what is the impact of to the extent that at the beginning and provided by or on behalf of the third party at the end?
Well, my lord, taking the second of your lordship's points first, by or on behalf of at the end, the CPE is typically provided in a one-box solution by or on behalf of the CP as the judge finds in the judgment. Dealing with your lordship's first point as to...
Yeah, yes, but
sorry, my lord.
The thing is that it's a repetition of something that has already been said. So we've already had reference to the products or services being provided on behalf of a third party.
Yes.
And so, and it then goes on using materials provided by or on behalf of the third party.
Indeed, my
So it's to some extent repeating what's already been said.
Yes, and it's the same third party in both instances on our construction. It's the CP that on whose behalf the service is delivered by BT and which supplies the customer premises equipment.
All right. And then what about to the extent that
Yes.
I assume, but I want to be clear that you're accepting that that's a limitation.
Well,
And you
yeah,
say you
I mean, the
satisfy
words.
it.
Oh, yes, I mean it's a requirement that we satisfy. If that's not, I hope, unduly playing with words, but
Well,
it's
it's a limitation on what goes before.
yes, my lord, and it's satisfied.
Can I be sure I understand? Just picking up what my lord says.
Yes,
To the extent that
yes,
suggests that it's not to the entire extent, it's only to a limited extent, and it's to the extent. I mean, when you were saying there are these three conditions and you satisfied each three of them, almost was as if the proviso at the end, to the extent that, could be replaced with provided that such services use materials provided by Sky. That was what you said was satisfied, that the DSLAM, what BT does, uses materials provided by Sky because it uses the CPE, which is the box that's provided by Sky. As I understand, that's why you accept that this only works with one box or wires only solution, because if there's a two-box solution and BT provides its own modem, then the relevant service doesn't use anything provided by Sky. Both ends, both in the street cabinet and in the customer's premises, the modem is provided by BT, so it simply doesn't tick that third box. But my lord's point's a slightly different one, which is not, which you do accept. Do you use materials provided by Sky? Because you say you do, and I don't know that that's really disputed. But it's to the extent that you use materials provided by Sky, does that cut down on which services you need, which services are licensed and which aren't? Because if I can take an analogy, if I suppose I have a service which I can either deliver using my own vehicles or somebody else's vehicles. When I'm using my own vehicles, I'm not using the vehicles that are provided by someone else. If I look at whether the service as a whole is something that is within this third part of the second sentence, you would say, yes, my service as a whole, delivering stuff, uses vehicles belonging to a third party, but it's only to the extent that I'm using vehicles belonging to a third party that I'm outside the license. But when I'm using my own vehicles, I'm inside the license.
My lord, I
Do
understood.
you see the point?
I
think that was the
see.
point that my...
Yes, and I understand the point. There are really two responses. First of all, to the analogy. Your Lordship's analogy is essentially the reason why we accept that the argument only runs in respect of one box VULA as opposed to two box. Because in your Lordship's analogy, in the situation where you're using somebody else's cars, you're not within the limitation. But if you, in your Lordship's former example, you are, and you're using it to deliver the entirety of the service. And that brings me to the second point, which is really the answer to my Lord Justice Arnold's point. There is no part of the service provided by BT that does not use the CPE, because without the CPE there is no service. The service is the delivery of the connection into the customer's home, and without the CPE in the customer's home there is no connection. And so in this context, to the extent that the products or services are provided using materials provided by or on behalf of the third party, applies to the whole of the service, because the service doesn't exist without the CPE. That's the submission, my lord.
Well, I think that's very helpful. I think I understand the submission. I think it does require quite a lot of unpacking of what the service that BT provides actually is and to whom it's provided, and that was the judge's point, and that's a point which I think you're going to come to.
Oh, indeed, my lord. That's grounds 1 and 2, and I'm not in any way.
Well, I don't want to take you
but
out of your course, but I think I understand the way in which you now put the to the extent question.
Just before you go on,
yes.
in response to the submission you've just made, what did you say to the fact that the service doesn't exist without the copper wires either?
Well, what that would mean, my lord, is if the copper wires, to alter the example, were provided by or on behalf of Sky or TalkTalk, which of course they're not. They're owned by BT. But what it requires essentially is that there is an essential component of the service without which the service cannot exist, which is provided by or on behalf of the third party. And it has to be the same third party on whose behalf the service is being delivered in the first place. In this case, it's the CPE, but altering it so as to...
The arrangement of the kit is adventitious, isn't it? Because the service is the same. I think you accept that the VULA service is the same, whether it's one boxes or two.
It's the same service that the end customer receives, but as the judge recognises at paragraph 16 of the judgment, there is a material commercial advantage to the CP in having a one-box solution, because that facilitates their brand recognition. So you have, and we're all familiar, I'm sure we've all got them, the box in the home that has Sky, TalkTalk, whatever it may be, written on it. So there is a commercial difference and a commercial advantage to the CP.
So what your submission is that what drives the construction of this patent license agreement is trademark considerations.
I'm not sure I'd go that far, my lord. It's simply to say there is a material distinction between the two situations, which means that it's not, I wouldn't use the word adventitious about it, but at any rate, if it is the...
Can you point to any language in clause 10.1 which is anything to do with brand? Or indeed anywhere in this patent license agreement?
My lord, yes, the third sentence.
Apologise, I did overlook that, you're quite right, thank you.
And that's, it's, and that's why I was making the point about the third sentence, because it does appear to be driving at a difference depending on whether, or on under whose brand the service is actually being delivered. Now, I'm not saying that one gets into the technical question of whether it's trademarks or whatever level of detail one may be talking about in that regard, but it clearly is a factor in here, and it, at any rate, your Lordship has my point. Paragraph 16 of the judgment makes the point that there is an advantage for the CP in having a one-box solution as compared with
I
a
understand that,
two-box.
but I'm still puzzled because we're talking about, I take your point about the third sentence, which I was overlooking. But even so, we're talking about a patent license and the service is the same. So why should it make a difference?
Well, my Lord, ultimately, it was the bargain that the parties struck, and if that's the outcome of the clause, then one would need to be looking for something in the realm of corrective construction to be departing from that bargain.
As long as that's the only rival interpretation reasonably available in the wording. I mean, that is your case.
I guess it is.
The wording is unambiguous, and so it doesn't really matter how sensible it is. That's the result, because we're not in the territory of corrective construction. It's not said this is a mistake in the language.
No, nobody is saying that. No.
And so that's really the scope of the debate. Is your way of reading this clause the only one that's reasonably available in the circumstances?
My Lord is right, that's the case under grounds 1 and 2.
Yes.
Under grounds 3 and 4, we say that the judge erred in her approach to commercial purpose, because what gets, in my submission and advertising where I'll be going later, what in a sense gets forgotten is the perspective of my client,
Well, your
which
purpose is to maximise your revenue, and their purpose is to minimise it. I understand that.
and my client has at this point, in July 2015, has a very substantial business in selling DLM software to communications providers, and therefore
But that's for the unbundled loop, the local loop and the sub loop. Unless you're right on this, as VULA spreads, you lose your customer base. That's your problem.
Well, my Lord, but in a sense that's where the commercial purpose issue arises, because of course it is in my client's commercial interest to ensure that doesn't happen.
Absolutely.
And if that's the effect of the bargain that the parties have struck, well, that's the effect, and there's nothing commercially irrational about it from the perspective of my client. And simply looking at it through the perspective of BT doesn't really assist. That's where I'm going on 3 and 4.
understand that. It doesn't quite answer, as I understood it, my Lord's point, which is that what you expect to get from a licence is there are certain things BT can do and there are certain things BT can't do. And it seems odd, I won't say it's uncommercial or nonsensical, but it seems odd that whether you can do something or not does not depend on what you're doing, but on whether somebody else uses one box or two. That seems odd, doesn't it?
Well, I'm not sure it's actually the somebody else
Well, it may not be
necessarily
somebody else.
using,
Okay,
using
maybe whether BT uses one box or two. You're still doing exactly the same thing, as I understand it. BT is still using the Rambo to control the DSLAM in the street cabinet, if I've got the jargon correct. It's exactly the same with VULAs with one box and VULAs with two boxes. What is actually being done in the street cabinet is exactly the same. Managing the communication between the modem and the box, the cabinet and the modem in the home. But what it depends on your submission, if I've understood it correctly, tell me if I'm wrong, is whether BT, or it may be Sky, but let's assume it's BT, decides to supply its own modem to the customer, a two-box solution, or decides to provide a wires-only solution and leaves it to Sky to provide the one-box solution. Have I understood that correctly?
My Lord, the distinction between one box and two box is, yes, that's...
Well, then what I was putting to you is it's odd the service which infringes the patent, which is what goes on in the street cabinet, what the Rambo does in controlling the DSLAM, which is exactly the same in both cases. Whether that's licensed or not depends on whether it's a one-box or two-box case. And I'm just putting to you that I think this was my lord. I mean, it's not my point. I think it was my lord's point. That seems slightly odd that it should turn on that, which is he said adventitious, but it doesn't really matter how adventitious it is. It doesn't seem to change what it is that BT is doing that would otherwise be infringing, which is what's done in the street cabinet.
There are a number of answers, I think. The first, obviously, and I think the court already has the point. If that's the effect of the words,
Well,
that's
I
the
have
effect
that
of the
in
words,
tab.
and there we go. If we look, but moving to the additional layers of response, there is nothing that makes that in any way commercially irrational from the perspective of BT, because it's not something that lies outside the control of BT, the format in which the service is delivered. But even if it did, this is ultimately a situation where the parties have divergent commercial purposes, and it doesn't really assist to say, well, why would BT have wanted to agree X when...
Why would you have wanted to agree? Why would you have wanted to agree that whether you get money from Sky in the Vula case depends on whether BT puts in a no-wire solution or a two-box solution?
But also, my question is not about commercial rationality or irrationality at all. It's got nothing to do with the money. It's to do with patents. It's to do with what a patent license is. It's about the use of claimed technology. The technical solution is identical in the one-box solution and the two-box solution. And it is therefore, from a patent perspective, not a commercial perspective, irrational, in the absence of something very clear, to say that the ambit of the license depends upon that factor. That's the proposition that I'm putting to you. As I understand it, your answer is, well, that's what the words say.
That's certainly my primary answer, my lord, yes. I mean, ultimately, I absolutely understand the submission, the point that my lord makes to me, to the effect that there is an infringement in both situations on the hypothesis that we're adopting.
Exactly.
I mean, as it happens,
absent the license.
At the time, to add to the complexity, as we know, BT was applying for summary judgment for a declaration of non-infringement as regards the only remaining patent that was said to be infringed, 790. So we don't know what considerations were actually in the mind of BT.
BT claim they have a workaround, and that's not for us to decide whether that's correct or not.
No, my lord.
But it's asserted.
It's part of the background, though, because one is in the end asking, well, and I do say we do in the end whether one examines it in terms
it's
of...
all or nothing on both sides' cases, because of course your client's cases at that point of position was you didn't infringe either way, and it was their assertion that they had a workaround which meant that they didn't infringe either way. So that's the background. But then one says, well, here's a patent license, and whether it covers the technical solution, which is the same either way, and is infringement neutral, depends on this question of whether it's one box or two. Seems odd.
Well, my lord, I don't think I can improve on the answers I've already given in those regards, but in my submission, the answers run whether one treats it as a question of commercial purpose or as a question of patent infringement. It doesn't actually affect the responses, because ultimately we have here two warring parties. They're litigating in three different jurisdictions. It's in my client's interest to ensure as much of BT's ongoing activity is not licensed as possible, so as to protect its existing DLM business. And it's in BT's interest, for obvious reasons, to ensure that as much of it is licensed as possible. As I've already submitted, if we're under clause 10.1, then we are inherently concerned with things that are otherwise licensed, because it only has any relevance if it's a carve out from the field of use, and that is DLM and DSL systems. And so to say that it's counterintuitive that there would have been a carve out from the scope of any license in relation to DLM or DSL is inconsistent with the fact that clause 10.1 is there in the first place. It has to mean something, and the only question really is what does it mean? What does it carve out? And that's
Sorry.
no, my lord. Sorry.
Let me tell you what I'm through my mind at the moment. I'm now struggling with existential angst because I am trying to not remember what was in the case that I decided.
Yes.
I don't really remember. I'll tell you that right now. Okay. But at the moment, I don't find it as puzzling as I know my colleagues may do, or Justice Arnold may do, that there's a difference depending on whether the box in the customer's premise is a box that was supplied by BT or a box that was supplied by somebody else, because this isn't just about what happens in the DSLAM. The DSLAM is talking to the box at the other end. These inventions are about a communication, and I don't think that's something I'm getting only because I decided the patent case. I think that's something I'm getting from hearing this appeal. It's about a communication between a piece of kit in the cabinet and a piece of kit in the home. And so it isn't obvious to me, at least, that it's there's anything odd about the idea that depending on whether the piece of kit in the home was provided by the licensee, BT, or by somebody else, Sky, necessarily is a difference which is an odd difference. Because in one case, all the actors in the invention are provided by the licensee, and in the other case, all the actors in the invention aren't provided by the licensee because the kit in the home is provided. So what I'm troubled about is the idea that the answer to the construction of this clause depends on some analysis of things like patent claims. Because that doesn't feel, A, it's not the way this case has been put at all, and B, it just doesn't feel like the right way to approach the construction of the license. So can you help me with that? Do we have to get into the question of whether, for example, is it a relevant consideration to say, well, we know that these patents are all about what happens is only about what happens in the cabinet, and that doesn't change. That troubles me because I don't think I know that. If you see what I mean.
Well, my lord, we don't have any of the infringement judgments in the bundle. We did have them below. And what I don't want to do on my feet is give my lord an inaccurate précis of the nature of the infringement. So if I may, I'll take instructions on that and come back to it if necessary. But my lord, I see your lordship's point that one shouldn't be unduly granular in attempting to sort of retrofit this clause to a specific infringement found in a judgment.
Well, indeed, and it's, as I understand it, it's common ground that we're not concerned with the question of whether, absent the licence, there would be infringement or not.
No, that's right, my lord. You're not. But I think where this issue arises is in relation, and I put it neutrally, to the probability or otherwise of the one box, two box distinction, whether one's treating it in through the prism that my Lord Justice Arnold puts forward, which is patent infringement, or the prism that my Lord Justice Nugee puts forward, which is broader commercial considerations. And in the end, we said a distinction between one box and two box is a perfectly rational and sensible one in circumstances where this clause itself denotes that it matters whether the service is provided using materials supplied by or on behalf of a third party. So it can hardly be said that that is an irrational or arbitrary consideration where the clause itself, one of the requirements is that it's provided using materials by or on behalf of a third party. That's the actual line that the clause draws. But then further, that the third sentence shows that considerations of the brand under which the service is delivered are not regarded by the parties as irrelevant, and to the contrary, are the basis on which there is then a get out from the carve-outs, as it were. it's very difficult to stand back from those words which specifically make the question of who supplies the CPE or whatever other component we're talking about that's essential to the delivery of the service relevant, and say that that is an irrational line or an arbitrary line or a surprising line for the parties to have drawn. That is the line that the parties drew. Now, in this context, and bearing in mind the time, I think that to make sure I make progress and finish by lunchtime, let me turn very quickly to the question of the heading to the clause, the words patent laundering, and which also feature at the end of the first sentence in brackets. And this heading is essentially a signal that we're moving into the territory of a clause that's designed to prevent third parties from riding on the coattails of the license without the other party getting an appropriate royalty. The first sentence identifies what might be described as a paradigm case of laundering in the context of manufacturing of products, and says in brackets afterwards patent laundering activities. It then seeks to identify something in the second sentence, which is said to be similarly, but necessarily not the same, because it is concerned with not with manufacture, but instead with the products and services of the parties. And as I've already made clear, that means, and can only mean, services that would otherwise be within the field of use. Now, neither party, whether before the High Court or in this court, has identified any English law suggesting that there's any settled concept of patent laundering or what the limits of that concept might be. And of course, if the clause used the expression without explaining it, then that might pose a problem. But here, the parties have taken the trouble to define their understanding of the concept in clause 10.1, which has to be applied in accordance with the terms of that clause. In paragraph 86 of the judgment, the judge found that the parties were aware of a concept of patent laundering, and as she put it, and at least in broad terms, what it typically involved. And if one looks in the judgment at 86 to 91, what you will see is that the essence of the concept that the judge thought was embodied within it was that the clause couldn't have been intended to effect a radical alteration and was only intended to cover something out of the ordinary. But there are a number of responses to that. First of all, the point I've already made that in fact the third sentence, and indeed the very fact that it's there at all, shows that the parties are contemplating that it must be carving out something that is otherwise within the ordinary business and field of use of the parties. There really isn't any basis in these words for suggesting that they're only intended to cover extraordinary or radically different activities. And we say, given that nobody has identified any settled concept of patent laundering, it's quite unsafe to bring a preconception about what that concept is and then use it in effect to control the meaning of the clause in preference to the words. Now, in that regard, in paragraph 44 of its skeleton, BT cites a US case, which it says embodies the basic concept, and it's also put an article from the Washington Law Review in the bundle. And let me deal just very briefly with those materials. They're in the supplementary bundle at tabs 1 and 2. And I can do this very quickly. At tab 1 of the supplementary bundle, we have an article that my learned friends rely on called Lost and Foundry. And it's from 1994, so nearly 30 years ago. And as one can see from the abstract on page 2, it does analyse the law as it was at that point, but as is clear from the 5 lines at the end of the abstract, it is largely, as the court will see, an opinion piece about what US law ought to be. And let me just show the court that. What we can see, there's discussion of the various cases, most of them involving Intel. The latest of which at this point was a case called Intel and ASSIA, which is explained at page 12 onwards. And you can see at page 12 in the middle of the page, we have, in 1988, ASSIA entered into an agreement with HP in which HP would provide foundry services for the manufacture of math coprocessors, embodying patents licensed from Intel. According to the agreement, ASSIA would supply HP with a proprietary design that HP would use to produce the coprocessors. HP was forbidden to use this design to make products for other companies. After HP manufactured the coprocessors, they were to be shipped to ASSIA for resale as ASSIA products.
I'm sorry, I appreciate you're trying to deal with a point that's put against you, but I'm really struggling to understand the relevance of this. I mean, there can't be any reason why these parties would have had this article in mind when making their agreement, particularly because US law in this regard moved on quite a lot, even by 2015, never mind what's happened since 2015, as to which there's been further movement. So why does this help us? And I appreciate you're not relying upon this, but why is it of any relevance at all?
Well, my lord, obviously our primary submission is it doesn't, and that's why I perhaps dancing around the point, at the start emphasised that this is an opinion piece from 1994 about US law. I mean, it plainly doesn't help in relation to understanding an English law agreement entered into in 2015. But I was attempting to sort of to meet the point, not just by saying that, but also that one can see.
I don't understand you to challenge what the judge has said in the judgment about patent law, as a general concept.
Well, my lord,
and that's as far as it goes.
Well, I'm afraid, and apologies for not being able to move the argument on, but that I don't accept, and the reason for that is that.
Which ground of appeal is that?
What, my lord?
Which ground of appeal?
Oh, I see.
Is that?
It comes under the commercial purpose and business common sense point, because the judge makes the point in the remaining sections of the judgment after she has dealt with the words.
I'm sorry, I'm baffled, because I haven't read any of your grounds of appeal of attacking the judge's finding as to what the parties understood by patent laundering. Surely, if you were attacking that, you would need a ground of appeal.
No, my lord, I'm not quite going that far. The point is this: the judge makes a finding that the parties knew about a concept of patent laundering and at least the basics of what it involved. The point I'm making is that it is very difficult from the following paragraphs in the judgment to discern any, in my submission, any precise adumbration of what the concept was understood to mean, and the submission in response to the points being made by my learned friends based on US law is that there is no, or at least no one has presented to the court any settled concept of patent laundering. And therefore, those words don't assist in interpreting the clause. That's.
Sorry, are you saying that the words patent laundering are to be disregarded?
No, my lord.
That would seem to require a ground of appeal which you don't have.
No, my lord. I'm dealing with, primarily dealing with a point made by my learned friends, but I am then, in relation to the wording of the clause, observing that in our submission, the words patent laundering don't assist in construing. I'm not saying they're irrelevant. I'm not saying they're to be disregarded. I'm simply saying that there is not a great deal to be extracted from them by way of assistance in circumstances where there is no settled concept of patent laundering and where the parties have taken the trouble themselves to define in clause 10.1 what they understood the concept to be, my lord. But that's the point. In the end, it's really a variant on, it's all about the words, my lord. The grounds 1 and 2 are concerned with applying the words. And we say that is the safest approach here. One shouldn't get distracted into what the concept was understood to be in 1994 in the USA, or indeed in 2001.
Well, I have absolutely no problem whatsoever with your proposition that the materials being relied upon by your opponents are utterly irrelevant. However, I'm still concerned that you seem to be challenging a passage in the judgment from 86 to 90 without a ground of appeal.
My lord, I appreciate your lordship's point. I can't improve on the point that it comes in under commercial purpose, which is the subject of grounds 3 and 4. But my lord, turning in that case to the grounds of appeal, that's the fourth of my 4 topics. Grounds 1 and 2 are developed at paragraphs 28 to 46 of our skeleton argument. Those 2 grounds are both concerned with and address the central passage of the judge's reasoning under clause 10.1, which one sees at paragraph 70 to 78 of the judgment. And let me take the court to that. It's in the core bundle, tab 10, page 105. The judge says, in order to succeed, ASSIA must demonstrate that the relevant product or service is provided by BT to the end user, since otherwise it could not be said that BT provides it on behalf of a third party, being the CP. It is certainly the case that the end user benefits from VULA, and then there's a description of the various benefits. 3 lines from the end of the paragraph, the end user might even have agreed to pay more to the CP to achieve a faster connection, but as already discussed, VULA is only one part of what is required for an end user to access the internet. And then we have what I think is the key plank in the reasoning. What is provided to someone must logically correlate to what is received by them. The end user receives what he or she has contracted for, namely internet access. Although it might at least theoretically be divided into different services, that is not what the end user has bargained for or in fact received. If internet access is not available, the end user will usually have little interest in the reason. They will just want it to be fixed, etc. And then at the end we have, in many cases, an end user may have contracted for additional services, but it's said that those are not relevant. Then we have a discussion of, well known from Mr. Saunders' Royal Mail analogy, which I adapted in reply, but which the judge didn't ultimately find helpful. 74, in contrast, it's clear that VULA is a product provided to and received by the CP. The CP must have the benefit of it to be able to provide the service that it has contracted to provide to the end user. If it were required to enforce its contract with BT, it would be doing so for its own benefit, to allow it to perform its own obligations to end users. It would not simply be seeking to compel BT to provide a product or service to end users in its stead. Then a reference to the DEA conditions. And the judge says it's worth noting that the end user would typically have no knowledge of or interest in the arrangements between the CP and BT. They may appreciate that they benefit from the faster speeds available with FTTC, but they'll usually be both ignorant of and indifferent about whether that's achieved using VULA or SLU, the choice between them being one for the CP to make. And there's a description of SLU, which we know about. 77, there's reference to a point I made that BT has full control of the portion of the connection covered by VULA, there being no handover to the CP at any intermediate point. However, this does not affect the fact that the service contracted for and received by the end user is the single service of internet access. So essentially, this passage stresses that the end user contracts for and receives an internet access service that the end user would have no knowledge of or care about which entity is involved in delivering the different parts of that service, that what is received must logically correlate to what is provided, and that since what the customer receives is a functioning internet service, of which VULA is only a part, VULA has to be regarded as being provided to the CP rather than to the customer on behalf of the CP. And we say, for all the reasons explained in our skeleton, that that is a wrong approach in principle. That's grounds 1 and 2. And there are 3 points I would emphasise here. Firstly, it is, we say, clear, despite the submissions made to the contrary by my learned friends, that this passage does examine the issue of construction throughout from the perspective of the end user contracting with the communications provider rather than the parties to the license agreement. That's clear and explicit in at least paragraphs 72, 73, 76 and 77. And that is not, for all the reasons I've explained when I was dealing with the principles of interpretation of the correct approach. Secondly, as we observe in paragraphs 38 and 41 of our skeleton, the consequence of that approach is that the judge didn't examine the issue or the question which is actually posed by the clause of the contract, which is what service was provided by BT. Clause 10.1 is a clause in a patent license agreement that asks whether a particular service provided by BT is licensed or not. In other words, the unit of inquiry is dictated by the clause itself. And it is of course true, as the judge adverts to in this passage, that a CP needs to do or procure many other things to ensure that the customer receives a functioning internet service. And there's a diagram that's been put in the supplementary bundle at page 225.
Before we get on to the supplementary bundle, I'm a little bit puzzled by the way you pose the question. You say the question is, what service was provided by BT? But I don't understand that to be in dispute. The service provided by BT is the VULA service.
Yes.
What is in dispute, on the words of the clause, is on whose behalf it is provided.
Indeed, my lord.
Now, do you accept that in considering on whose behalf it is provided, it is relevant to take into account to whom it is provided, or do you say that's irrelevant?
We accept that, my lord, and we've explicitly accepted that in our skeleton. So I'm not seeking to go back on that.
So, what is wrong with the judge's conclusion that BT provides a service to the CP, that is to say VULA, and therefore it's not being provided on behalf of the CP?
My lord, that's the point I'm attempting to develop under this second issue, which is that it essentially starts by saying, what is the sum total of what the customer receives in a functioning internet access service? And works backwards from there. It examines the whole thing from the perspective of the end user. And of course it's right that there are a whole load of other things that need to be in place in order for the customer to have a functioning internet service. That, as I say, there's a diagram at page 225 of the supplementary bundle, which has been put in by BT. It was an attachment to Mr. Linney's evidence, and I'm not going to go through the whole thing, but what the court will see is this is essentially a sort of description or a depiction of the sum total of all of the equipment, products and services which are cumulatively necessary for an end customer to receive a functioning internet service. And as a result, it has all sorts of things on it. At the left-hand end, we have the customers having a computer with a browser, and at the right-hand end, we have the CP operating legal intercept on behalf of the law enforcement authorities. We have a domain name resolution service, etc. And we say, examining all these other elements of what a customer might receive or need doesn't help in answering the question posed by clause 10.1, which is whether the part of the service which is delivered by BT is delivered on behalf of the CP or not. Of course, the customer does not much mind, and this is the point the judge makes in this section, or even know what part of the service being received by him is being provided by BT. But we say that's nothing to the point when one is looking at clause 10.1, which asks the question, well, look at VULA, look at the part provided by BT, is that provided on behalf of the communications provider? And we say if one asks that correct question, then the only sensible conclusion is that VULA is provided on behalf of the CP. And we make that point in paragraph 41 of our skeleton. It's also the subject of ground 2. But I've taken these grounds together because they both attack the judge's central reasoning in paragraph 70 to 78. Ground 2 is effectively the consequence of ground 1. We say that once one takes out the error of asking from a customer's perspective what the sum total of what they receive is, then on the judge's own findings, we say plainly the service is delivered to end users by BT on behalf of the CP. As I showed you earlier, the service is delivered all the way from the exchange by a fibre cabinet connection to the street cabinet to a DSLAM, and this is all BT equipment, to a DSLAM in the street cabinet. BT manages the DSLAM using its DLM software. It controls the process of communicating the signals along the wires between those items of equipment. The wires extend into the customer's home. The GEA conditions I've shown you make clear there's no handover back to the CP at any point. BT solely controls that data connection delivered directly into the customer's home. That's judgment paragraph 68.
So the points you're making now show convincingly that the end user benefits from VULA, but is that sufficient?
I would probably say it's necessary but not sufficient because it's not precisely the same question, my lords. But we would say in the end, this is, if one looks at the facts the judge has actually found, to say that this is not a service being delivered to the end customer, once one takes away the error of asking whether everything on Mr. Linney's spectrum is delivered by BT, the suggestion is isn't a service delivered to the customer is inconsistent with the findings that were actually made.
How do you distinguish between, in a situation in which there's somebody who provides services to a customer, let's say haircutting services, barber shop, how do you distinguish between a situation in which that service provider themselves get services from somebody else, say cleaning services for the shop? To my mind, if you go to a barber shop and you get your hair cut, you're getting services provided to you by the barber, and there's no question that the barber is providing those services to the end user, that's me. The cleaner who is cleaning the shop doesn't feel to me like they're providing services to me, they're providing services to the barber. So the only point I'm trying to make, I haven't thought this through, but the point I'm trying to make at this point strikes me is that just because a service provider provides services to a customer and that service provider necessarily gets services from other people doesn't answer, it's not enough to answer the question whether the services which are provided to the service provider are necessarily services which are in fact provided to the end user. The point of my question is to say, given that feels
Yes.
obvious, how do you decide in a situation in which services are provided to an end customer? How do you distinguish between the cases in which what's really happening is that their services are, as it were, being fed through and being provided on behalf of to the customer, and the case in which they're not, the barber's cleaner case? What's the distinction?
Well, I suspect that what lies behind my lord's intuition that the cleaner would not be within, but the actual barber would be, is that the barber is delivering the services directly to the customer who's sitting there in a chair having his or her hair cut at the time, whereas the cleaner operates perhaps when the customer's not even there. If that encapsulates a dividing line, then our submission would obviously be that we are very firmly on the barber side of the line, because we have here a situation where there, as the clause makes clear, there is no handover back to the CP at all. BT is delivered, these signals are being delivered all on a continuous basis from the exchange, through the DSLAM, through BT's copper wires, into, and through wires that actually form part of the customer's home, into the CPE. And this is a kind of ongoing, it's as if somebody were having their hair cut on a constant basis, my lord, which doesn't sound very comfortable, but that's the equivalent. And to say that that is not a service being delivered to the end customer, once one strips away this approach of asking, well, you know, what about lawful intercept and all the other things that you need, to say that that is not a service delivered to the end customer, we say really just doesn't make any sense. And what one has to bear in mind here, I've accepted the point put to me by my Lord Justice Arnold, that we accept that this is a relevant consideration when asking whether a service is delivered by or on behalf of, and I'm not going back on that in any way. But it is important to remember that this whole question of to whom the service is delivered arises only as part of a thought process in trying to answer the contractual question, which is simply the words on behalf of.
No, it's not the words on behalf of, well, it is the words on behalf of, but you accepted if the service that BT delivers is delivered only to Sky and not to the customer.
My lord, yes, I have.
Yes.
That's quite right, and that's in our skeleton argument, and not, as I say.
Can I put? I mean, analogies are dangerous, as the judge herself says, but sometimes they help to tease out what is the real issue. Can I put a different analogy? If I want to go by train from London to Bristol, I buy a ticket from a train operator, Great Western Railway, and they provide me with transport from Paddington to Temple Meads. That's what they do. Now, in doing that, they make use of a whole range of services provided by other rail companies. They might lease rolling stock. They certainly use Network Rails. They might use signalling provided by some other entity in the rail thing. Are those people, the people who lease the rolling stock to GWR or Network Rail, who gives them a license to use their rails, or the people who maintain the rails, or the people who provide the signalling, are they providing me with a service? Or are they providing GWR with a service to enable GWR to take me to Bristol?
Well, I think in the end, it's probably actually the same sort of issue as arises in respect of the barber example, because the question is going to, in the end, depend on whether there's a kind of direct interface between the customer and the provider. And in this situation, I mean, and of course, you know, leasing a rolling stock, the customer's really not involved in leasing a rolling stock or anything like that. The answer might be, actually, I'm not going to take the analysis into people delivering catering on the trains and that sort of thing. But in the end, in this case, we have a situation that I've already made the point, where there really can't be, it's not as difficult as either of those examples, because you have a situation where the signals are being delivered along a system which is entirely BT's apart from the CPE in the home. They're being delivered via wires to a socket in the customer's home. And on any ordinary understanding of that, that is BT providing a service to the customer on behalf of the CP.
Yeah, but the judge's reasoning is to say the customer isn't at all interested in VULA. True, that's the technical solution that's been adopted, but that's not what the customer is getting. And therefore, VULA is not being provided on behalf of the CP. Because if it was being provided on behalf of the CP, then it would be being provided on behalf of the CP to the end user. The end user isn't buying a VULA service. That, in a nutshell, I think, is the judge's reasoning.
My lord, that, without repeating what I've already said, is where that is one of the areas, if examined by grounds 1 and 2, where the judge goes wrong as a matter of approach in our submission, because she starts by saying, well, look, what does the end customer receive here? It's the whole of Mr. Linney's diagram. And as she puts it, I think at the start of paragraph 72, what is provided has to correspond with what's received. And one then gets to the inference that therefore BT can't be providing VULA because VULA is just one part of what the customer gets. But we say that's really not the right approach. First of all, because, well, for all the reasons I've already made in relation to the fact that that's not the correct approach to interpretation. You don't ask from the perspective of the customer. But also secondly, because it's not the unit of inquiry dictated by clause 10.1 itself. 10.1 is asking, well, is VULA provided on behalf of the CP or not? And so saying, well, there are lots of other things doesn't really help.
As I understand it, Mr. Segan, I don't want to put words into your mouth, but the way I've understood your submission is you say, it's just, or in my mind, you've never actually said it, but that VULA is being provided to the customer. The VULA service is provided to the customer because it's part of their internet access. It's not the whole, but it's part of it. I'm not trying to paraphrase, but
yes, my lord. Yes, that's ground 2, but it results from ground 1, because ground 1 is the error of approach. And once one removes the error of approach and asks, well, looking on the basis of the judge's own findings here, judge's own factual findings of what actually happens, is this a service being provided to the end customer? The answer is yes. And that's ground 2. And it's said against me that that is a finding of fact, but our submission, it's plainly not a finding of fact. The underlying facts about what BT actually does, where its signals go, what contract it has in place with the communications provider, and all those issues are agreed.
Yeah, it's an issue of contractual construction.
Yes, my lord. And the question under clause 10.1 is whether, in view of those facts as found, BT is to be regarded as delivering the services on behalf of the CP or not. And in order to answer that question, does a particular set of facts fit within a contractual wording? One has to ask a question of construction. So to say it's a question of fact, we say is wrong. But if it matters, we also say that if it is to be regarded as an evaluative judgment based on facts, then a classic situation for an appellate court to intervene is where there's been an error of approach. And that's covered in the White Book at 52.21.5, but I take it as axiomatic. So even if it's an evaluative judgment, if there's an error of approach, then the court can intervene. And that's grounds 1 and 2. In relation to grounds 3 and 4, they address the remainder of the judgment after the sections on the actual wording of 10.1. In particular, paragraphs 97 to 101, which deal with patent peace and the settlement agreement, and paragraphs 102 to 114, which deal with what the judge describes as business common sense and factual context.
Just before you get into the detail, can I just ask you a general question at this point? Would you accept that the real issue between the parties as to the interpretation of this agreement is as to the breadth of the words "on behalf of a third party"? From one perspective, it can be said you're taking a broad view of that, whereas BT are taking a narrow view of it. Now, the follow-up question is, if that is the right way of looking at it, can you submit that there's only one possible view of the breadth of those words?
I appreciate the point that you, my lord, putting to me. The primary submission under ground 3 is that we say, in fact, there's really only one sensible understanding of the person to whom the service is being supplied here, and therefore, since it's the thought experiment that we're deploying for the purpose of answering the contractual question on behalf of, there's similarly only one real answer to that question. And it's worth noting that I think in paragraph 80 of her judgment, it's a point I've already made, but the judge indicated that she was with ASSIA on the question of on behalf of, but for the point about to whom the services are regarded as being supplied. So that's the primary submission. That's ground 3. We say in those circumstances, business common sense, as the judge puts it, ought not to have come into the matter. And I've already made the point about McQuitty in that regard. There's no case made that we need a corrective construction here. But if you're not with me on that, one then turns to ground 4, under which we say that the judge's conclusions on commercial purpose were not in accordance with the correct approach in any event. And we've started in paragraphs 55 to 58, I hope respectfully, setting out some well-known judicial cautions against what might be described as the overzealous identification and application of what is considered to be common sense, business common sense. And in essence, we say, with respect to the judge, that those cautions were not heeded here. The first point we make under ground 4A is that the judge wrongly approached the issue of patent peace effectively from the perspective of BT alone. And if one looks at the judgment, for instance, at paragraph 107, which is in the core bundle at page 111. The judge says, it's important to bear in mind the nature and content of the dispute that the licence and settlement agreement was intended to bring to an end. There's reference to the fact it was a dispute about DLM and Rambo, etc. The judge says in 108 that 3.1 allowed BT to continue to provide VULA. We don't dispute that was the grant of the licence. The question is whether 10.1 carves out or not. 109, it's found that my client was aware of the existence of VULA and that it was being provided to CPs and the such like, and we haven't taken any issue with that. Thirdly, it was also not in dispute that the aim of the settlement agreement and the licence was to achieve patent peace, and there's reference to discovering the genesis and aim of the transaction. And in 111, the judge says, and this is really the punchline of the point, if ASSIA's construction were correct, then the settlement that the parties purportedly agreed would in truth not have ended the dispute and achieved patent peace. on ASSIA's case, BT would have been in immediate breach of the terms of the licence in continuing to provide the VULA product to third-party CPs. Such a construction would require very clear words. Now, just pausing there for a moment, that in at least one limited sense, that is indisputably incorrect, because referring to being in breach of the licence is not right. If it be the case, as we submit, that clause 10.1 carved out from the scope of the grant the ongoing supply of one box VULA on its proper construction, all that would mean is that that did not fall within the scope of the licence, and the question would then arise, is that an infringement? A question on which, as we know, BT took the view that it wasn't, and that it had already worked around and was applying for summary judgment in that regard.
Isn't all that she means, when she says in immediate breach of terms of licence, that what it was doing was not licensed by, it would mean that what it was doing was not licensed, and that would have the consequence that it would reopen the question as to whether BT's workaround was infringing or not. Which is it a false point to say one can see that the settlement agreement was designed to put an end to that dispute?
I'll come to the macro point, as it were, that my lord is putting to me in a moment about whether it's rational, surprising, whatever. But in relation to the specific question of being in breach of the licence, the reason I make that point is that in fact occurs on, I think, 3 occasions in the judgment. So paragraph 82, the judge makes reference to, you can see in the middle, well, towards the end of paragraph 82, there's a sentence beginning, therefore, if ASSIA's construction were correct, then whether BT was in breach of the licence would depend on what, from the perspective of its provision of the VULA product, is the happenstance of a choice being made, etc. And the same point is made in 105. Further, the fact that the existence of a breach would depend on the end users, etc.
Yes, but isn't it a semantic point? Because if you substituted covered by the licence for breach of, the judge's point would remain.
Well, my lord, to an extent, yes, and that's why I've started by making it as the micro point compared to the macro one. But it's not irrelevant, because on the judge's understanding, and the reason she makes reference in paragraph 111 to requiring very clear words, is the apprehension that on our construction, BT would have been in breach of contract from the word go. And that is, strictly speaking, not correct. It was simply, as my Lord Justice Nugee rightly puts to me, have reopened the question of infringement on, as to which we know there was a summary judgment application in place.
There's a technical error in the judge's reasoning if read literally. But, I mean, to rephrase the point, I mean, this was a clean break solution. And on your construction, it's not a clean break at all.
Well, my lord, that's the macro to the micro points, and let me make my points on that. We say, in essence, that the judge wrongly approached the issue of patent peace, effectively from a perspective of BT alone, because it was said, well, it's in BT's interests to ensure that as much of its business is licensed, and therefore anything that results in the VULA business not being licensed is to be regarded as surprising. But
that's why I use the expression clean break, because the point about clean break settlements is that they're supposed to be for the benefit of both sides, because both sides are relieved from the burden of further disputation.
my lord, yes.
So why is that looking at matters purely from the perspective of one part?
And the answer is that because this was, on any view, not a settlement which was intended without qualification to cover the entirety of the business of the parties as embodied in the field of use. The existence of clause 10.1 shows that the parties did indeed intend to carve out from the scope of the licence activities that would otherwise have fallen within the field of use.
I understand that point, but it's not quite an answer to my lord's point. because, or the judge's point. The judge's point is this, that everybody knew at the time, and I don't understand you to dispute this, including your client, that BT was providing Vula. It is, at any rate, unusual to find a settlement agreement which is designed to settle litigation, as you've said, across the globe, that what the settlement agreement does is set up a license which contains within it the potential for further dispute, which would have been appreciated by both parties at the start. It's not that if BT goes into that area, then we'll have a dispute, but doing what they're doing at the time reopens the question of infringement or no. As my lord says, if you settle litigation, it's generally regarded as for the benefit of both parties, because nobody has to spend any more time or resources litigating.
Well, in the end, though, my lord, this was a situation where, if one examines that critical question of, well, what was the incentives of the parties here, and it's a point I've already made already, and so I won't labour it. The incentive of BT, yes, was to ensure that as much of its business, as much of its Vula business was licensed as possible. The incentive of my client was not, because it had a very substantial business in supplying DLM software, DSL Expresse, as the judge finds, and so its commercial interest was ensuring that that business was not cut down.
I suppose you might say, Mr. Segan, that if BT, both sides knew that BT thought that their Vula business didn't infringe anyway.
Well, that's certainly a relevant factor in all of this, because, and that's why this issue about whether it's a breach of the license or just an alleged infringement comes in, because one can see if the submission is, well, this would have immediately put BT in breach of contract, then one can see the purchase of the point. If the submission is simply that it identifies an area of activity which is potentially a patent infringement, but against a background of facts where BT was in the process of applying for summary judgment on the issue of whether it was an infringement or not, and one then asks, well, is it commercially surprising or irrational or arbitrary or whatever word one might use that BT might have been prepared to take that risk? The answer is no. The second point under this heading is that there are no findings as to the scale of the activity that would have been left unlicensed at the date of the conclusion of the agreement, or indeed about what my client could have found out about it at the time. So you have a finding in paragraph 14 of the judgment that the majority of lines in the NGA network use VDSL2. You then have a finding in paragraph 27 that there were 4 million lines using VDSL2 in early 2015. But there's no finding as to how many of those lines were BT lines, which of course aren't touched by our argument, and how many were other communications providers. I should say, just purely from the interest of transparency, and so I'm not making an unfair point there, that there was evidence before the lower court. It's not in the bundles. The judge didn't make any finding about it, but it was evidence from BT in Mr. Ratcliffe's first statement at paragraphs 30.1 to 30.2, and the net effect was that the figure for other CPs was less than 1 million. But I'm saying that simply so it's not said that I've made a misleading submission by referring to the fact that the court didn't make any findings. There's nothing in the judgment to suggest that the figure is any particular number, and of course then, perhaps even more critically, there's no finding at all, and indeed there was no evidence as to the number of one box lines at the time being run on behalf of other CPs. So the portion of lines that would have been carved out from the patent piece in July 2015 is not ascertainable based on the evidence, and there are no findings, nor is there any suggestion that my client could possibly have found out about it, which is the relevant question for the purposes of interpretation. Thirdly, there's the point that BT considered that it had already implemented workarounds, which is the point that my Lord Justice Birss has already put to me. Ground 4B we address at paragraph 73 to 74 of our skeleton. And essentially we submit here there really wasn't any basis for finding that the outcome contended for failed to accord with business common sense. And 4C is paragraph 75 to 78. And the point is essentially elevating commercial common sense or business common sense to an overriding criterion, contrary to the guidance that I showed you earlier. We say in the end the guide always has to be the words of the provision. Finally, I should say something about ground 5. That's developed in paragraphs 79 to 80. There's an issue between the parties as to whether it's fair or not to grant a further declaration about the ambit of the field of use. But I'm not going to develop the submissions beyond our skeleton argument on that point, simply because in the end, the reason that the judge granted that declaration is that it was inseparable from the issues under clause 10.1, and one can see that from her additional reasoning at tab 9, page 86 of the core bundle. The declaration in issue is at paragraph 1 of that bundle. That tab at page 84, and then the reasoning is at page 86. And under the heading declaration in the second paragraph, the judge says the declaration relating to BT's field of use is justified by reference to paragraph 95 of the judgment and the very close link to ASSIA's claim in respect of clause 10. The points cannot really be separated, and granting the requested declaration naturally flows from the resolution of the claim. And so, in essence, if ASSIA succeeds on clause 10.1, then the basis for that declaration on the judge's own reasoning falls away. Whereas if ASSIA does not succeed on clause 10.1, then the point ceases to matter anyway. And so I'm not going to add to what's in the skeleton on that point. That brings me to 1 p.m. I'm conscious that my Lord Justice Birss asked a question about the underlying infringement proceedings, and I want to make sure that I've taken some instructions on that. So I won't formally finish now, but
Yes, well,
those are essentially my submissions.
it's always the case that the appellant takes more time. You know, the appeal from the respondent takes almost always takes to respond. So I'm sure it won't be a problem if you take 5 minutes after the short adjournment. Very good. We'll resume at 2 o'clock.
All right.